you're live.
All right. We are calling this meeting of the Akron Civil Rights Commission to order. We have a quorum present. And so we will move to the agenda. Our first order of business during this period, and I have a question about this after we do it, is just to consider suspending the rules requiring in-person attendance and voting and in-person sort of public comment. So do I need a motion? Can I have a motion to suspend the rules requiring in-person meeting?
So moved.
Second.
You got that? Like, I don't know sure who made the motion and who seconded it, but they
Yes,
were. It was made and seconded. Any discussion? All in favor say aye.
Aye.
Any opposed? So those rules are suspended. And we had minutes distributed just this afternoon. If people had a chance to review them, then we could have a motion to approve them, or if people wanted a minute to review, that'd be all right too. Any I'm open to a motion.
I move that we accept the minutes of last month's meeting.
Is there a second? Actually, I will second. Any discussion?
The Tonda, it's neither really here nor there, but technically my name only has one N in the middle. It's correct at the beginning, just in the body, in the content, it has two.
I will adjust.
All in favor say aye.
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 Any opposed? The minutes are approved. We have a couple of items of reports on investigations on complaints. And the first one is 19 ACRC 00013, and that is Commissioner Pitt. Do you have a report?
So I would like to make a report. I would preface my report by saying that it comes with, it's going to be followed by a question to the commission about whether you would like me to continue on or not, in that I've reviewed all the documents again, planning to make a report to you tonight, but I am actually no further than I was last month. So hence why I'll end with a question. Reviewing all of the documents and having reached out to the respondent and not being able to, they have limitations due to COVID on the ability to visit them. And we agreed that I could do interviews by telephone, but those have not been arranged. And I'll explain what interviews I was thinking to do. But the report I'd like to make is that the complainant, Mr. Watson, had, I think it's a total of 6 violations leading to his termination from Coca-Cola, the respondent. And these are all well documented, and I've received the documentation from Coca-Cola. Mr. Watson does not dispute the content of those violations or corrections. What he does, what his case was that that they were unfairly applied to him. So they included, he is an order builder at Coca-Cola, which means that he operates a forklift machine to move stock onto and to form a pallet that then goes out to the client. Those pallets, the company explained that there was a work study done some years ago that eventually the conclusion of that was to form an idea of how long it should take order builders to build those orders, and they were assigned a system to use to track their productivity. And that system includes the ability to punch out, if you like, for various reasons. One of those reasons that is in play here in the situation is called replenishment. And replenishment is when the stock is not available, which is why I explained the process. When the stock is not available and has to be restocked in order to be added to that order. So the complainant alleges that everybody under replenishment takes personal breaks, but that he was unduly written up for taking personal time. Yet he acknowledges that that is the rule, that you are not supposed to use that time for personal reasons, to go and make a phone call or to go to the restroom. So he acknowledges that. The company has a well-documented policy that that is not allowed without the approval of a supervisor. And Mr. Kendrick acknowledges that he did not receive approval of his supervisor to leave the floor at that time, but says that, quote, everybody does it. The other issue at play is dress code on the premises. And Mr. Kendrick alleges and has actually a photograph of a co-worker of who is white, who was dressed on the day that Mr. Kendrick was written up for not being in uniform, which is a particular color and style of shorts. Mr. Kendrick alleges that the co-worker was not disciplined for the same infringement. However, I have not been able to, I'll go back to what I haven't been able to do. And the company, again, has a well-documented policy around uniform, and Mr. Kendrick acknowledges that he did violate that policy. So the company feels that they fairly terminated him, and they quote their non-discrimination policy. They have extensive verbiage around that, and apparently allege that they do, or assert that they do training for all of their management in non-discrimination, that they have, and that there was not discrimination in this instance. So I have spoken with a co-worker of who worked alongside the complainant, and he alleges that or agrees that the complainant was targeted to some extent during the process of being written up. A number of, in this plan that they speak of, that is a union approved plan. And the company, the company asserts that they are employees at will, but that they chose to go through this process that they worked out with the union to give people a chance to address behaviors and shift, and that the complainant didn't do that. The co-worker says that that certainly there was some targeting, but that the co-worker doesn't feel that that was based on race. And at the same time, the co-worker acknowledges that they themselves are white and don't have necessarily a shared experience, but that by their observation, they did not see that to be about race, because there were many other people of color working at the company, etc. That individual no longer works at the company. I tried, as I explained last month, to reach out to other co-workers that the complainant did give me personal contact information for. They have not, no one else has responded to me over the months in between. And so I had requested to meet with the company and the supervisor, because my idea was, my conclusion from the materials I have at the moment is that there is not probable cause for discrimination given the overarching circumstances. And but my hope was that I would be able to interview the supervisor to ask about the co-worker who was in violation of the uniform policy, who was white, and see whether a violation was issued in that instance, whether the supervisor was aware of that instance, whether there were extenuating circumstances such as the photograph was taken after hours, or what is the supervisor's perspective on that to explain or to justify. So my question at this point, I mean, I don't know that I'm giving a solid, I'm happy to answer questions. And my question 2 is, would you like me to continue with the investigation? My understanding at this point, given the circumstances and the documentation that is available to me, is that my recommendation is unlikely to change, given what I know at this point from other co-workers, that there is not probable cause of discrimination.
Thank you. I think it might be useful, since we have not had a lot of complaints sort of reach this stage, right, with all of the commissioners who are here, to just sort of review the rules, right? Our process. And John, maybe you can help me with this too. So, the way this works, right, the complaint comes in, and we make an initial determination, even in order to start the investigation, just whether there's something to investigate, right? Whether it's within our purview, and when the investigation comes back, right, there is to be a recommended finding as to whether there's reasonable cause to believe that the respondent has engaged in a discriminatory practice. Right? And on receiving that report, I'm just reading from the rule here, the commission shall either make a finding as to reasonable cause or direct the investigator to continue their investigation upon a vote by the members of the commission. And there's also another provision for replacing an investigator under certain circumstances. And then if we say there's reasonable cause, then we send a letter to the parties stating the basis for the finding, and the optional conciliation process starts, right, where we assign a different commissioner to contact the parties, tell them we found there's reasonable cause to find that there's discrimination, and then give them an opportunity to work things out, short of holding a hearing. But then I think we do schedule a hearing, like right at this point, even though we're going to give them time to conciliate. So we're at this point of sort of making the finding, right? And so I guess the question is whether we feel that the report is sufficient to base a decision on, and go from there. Yeah, Nancy.
Okay, so I find it interesting that we have some evidence that there was disparate discipline potentially applied to the complainant vis-a-vis a white guy who was out of uniform. I want to follow up on what you said, Nanette. I think it's a very good, thorough report, but what is it about that potential disparity that would still not change your mind? I'm confused.
In that, and this is why I'm open to your saying to me, go ahead and do more. And it's what kept me going for those months. But in reviewing the whole case most recently, I was left to see that there, to realize again that there are 6 different violations or disciplinary actions leading to a termination. And so this is concerning only one of those. And even in that instance, the, so I don't know if the issue at hand here is the termination of this complainant, then I don't think that was solely discriminatory. Does that mean that there's potentially discriminatory management practices happening in the company by a supervisor? that possibility still lingers in my mind. But does that bring into question the termination? I'm not sure that I connect those dots entirely. But again, that's why I wanted to bring you some report and have your guidance and questions.
I see. Now, this uniform violation was the last violation which caused the termination?
No.
Okay. Would he have remained employed but for that one violation contributing to a total of 6? I mean, if we took that discipline out, would he still be there?
There were two subsequent violations after the uniform violation. Two following after.
Okay. But is it your understanding that if we threw out the one concerning, disparate application of the uniform standard, he would still have one more bite? Does that make sense?
The complainant had previously been terminated from employment at the company in April of 2018. That went to some sort of council with the union, and it was decided that it was premature to a disciplining process. And so another chance was afforded.
A last chance agreement.
A last chance agreement. And then subsequent to that, later in 2018, this process that is before us now went into effect with 6 separate.
Okay, that's extremely important to my understanding of this. So
yes, sorry, I couldn't find a way to mention that earlier.
No, it's a complicated case, I think. It's also a big company. And I guess I'll say that all of their policies and proclamations about being an equal employment opportunity employer generally don't mean a whole lot. Really what we want to know is what they did. But it sounds like the last chance agreement coulda, woulda, shoulda resulted in his termination after the very first violation subsequent to that. I agree with you.
Other thoughts or questions? I have a question. So there were 6 violations. One of them was a uniform, and at least one of them was a what did you call it? Replenishment, taking a break, saying it was replenishment, but taking a personal break. Was that? Is there a way to characterize? Was that all the rest of them, or?
4 are replenishment.
Okay.
1 is uniform, and 1 is also leaving a work area. The first one is leaving a work area, but it was not under replenishment. And the issue from the company standpoint with the replenishment is that it is considered fraudulent to clock the time as replenishment, because when you clock it as replenishment, it does not negatively affect your performance numbers. So it has another implication for the employees that does not bode well with from the company's perspective. Because there are other ways you can clock time off, but of course, eventually they count against your productivity.
So my question about that was, his claim is that, well, sure, it's true, I took a break and called it replenishment, but everyone else did too, right? And did the coworker confirm that? I wasn't sure what the coworker was confirming.
The coworker confirmed, yes, that sometimes under replenishment, they all sneak away, because replenishment can be anything from 5 minutes to 40 minutes, and they never know how long it is. The complainant alleges variously, depending on the occasion, most often that everyone does that, but also that the supervisors are not always readily available to give permission to leave the floor, and that he had an important personal phone call that he felt he needed to take, is the other reason given. that is not documented anyway. It was not a phone call where he could offer any, you know, a call from a hospital or a doctor or something that could be that I could track. It was not important in that sense, that I could verify.
I have a question, Nanette.
Yeah.
So you're saying that prior to these 6 incidents that you captured, there had been similar, I'll say, behaviors that the union mitigated? Is that what you're saying? Okay.
Yes, I do not know the details of those, but I'm led to believe that there were enough violations prior to April 2018 when he was first terminated that led them to a termination. But then the union determined, they agreed with the union that it was done during, that it was done a little prematurely. And so it was they determined that they would do one last chance.
Mm-hmm.
They
Okay.
agreed to, they negotiated that.
Okay. So your question is, your question to the commission is, should you continue to pursue? Okay. I have just a few questions that I have some concerns about that, but I guess the number of people that this manager supervises, how many are Black, how many are white, and maybe an overall look at the number of write-ups that this manager issued, just quantitatively, and then looking at the numbers, and then the numbers of violations per person. And we're getting down into the weeds, but those are just some overarching questions I had. But my main question was that the union had intervened before to try to restore his employment. That's my overarching question.
And in this instance, the union has also weighed in. I think it's fair for you to know, and
Okay.
has upheld the termination in this instance.
Okay. All right. Thanks.
Question, Nanette, what were the terms, if you recall, of the last chance agreement? Was it no violations over a specific period of time? A, and then B, how many violations occurred after the imposition of that last chance agreement?
Sorry, say the second part of that again, Esther.
How many infractions occurred after the last chance agreement was put in place?
6 infractions occurred after the last chance agreement was put in place, later in 2018.
Mm-hmm.
And then sorry, let me just check this note here. I do not know the terms of that last chance agreement.
Mm-hmm.
I would need to ask more. I can't see a note here. I don't believe I was given any detail on that.
It would be fair game to ask for a copy of the last chance agreement, though I can tell you guys that they're what they sound like. A last chance agreement is an agreement negotiated by the union between employee and employer, and it provides that, you know, we'll bring you back on, but if there is one more infraction
Right.
within a certain period of time, all bets are off and you're terminated. But, you know, it would be a not unreasonable ask to see it, though I think that it is what it is.
Mm, 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 mm.
I think
So,
that would be a good, if you will, a final view. Yeah, I agree with Nancy. It's last chance is last chance, and if the union has already gone to bat, there just seems to be maybe a history of violations connected with this individual. So just for some conclusion, I think I'd like to see the last chance agreement, but that is last chance.
So,
To your point,
go ahead.
okay, to your point, Gina, I would find it, I'm actually kind of interested in the demographics of it as well. Because, you know, certainly there's the person who, wow, they get written up a lot. But if they are the person who's, I don't know, profiled to be written up, or other people are doing those things, then, you know, it's going to be disproportionate. And I'm not sure that any one of these things, either the agreement or the demographics of the supervisees, would be conclusive. But I kind of feel like that's some missing pieces that I would love to know, if it's yeah, as a bit of information before closing the book on this.
And honestly, at one point I had spoken with Yamini about whether or not to request all of the write-ups from the supervisors in question. I'm not quite sure how whose responsibility it would be to tally those up and to analyze them. To be honest, over the last 6 months, I have not had the ability to dedicate that time, and I'm not sure. So if we were to do that, I would welcome someone else's assistance with that portion. I'm happy to continue to, you know, to be in. I am already in this conversation with the law firm to see if we can arrange the interviews, you know, and so I'm happy to continue with that. They simply, I didn't hear back in time for tonight's meeting. And I imagine that they've got some liaising to do with schedules and so on. But it feels that it will be a task to certainly sort through, assuming that there would be numerous violations. And we could certainly ask the company for the statistics of employees' racial identity or self, you know, is that appropriate to ask for? I'm assuming. It sounds like you would like to know that.
That's periodically reported on something called an EEO1. You could ask them for their EEO1, which would give you the breakout.
Okay, great.
A decent starting point. But you could also drill down and ask for the racial makeup of that concise work unit. And also ask them to, here's how to keep it really narrow. Ask them to identify white employees who were written up for same/similar violations for a period of time. And if they come up with none, is it dispositive? Maybe. I'll tell you what would be great would be to have some of this guy's coworkers, even just one. All it takes is one white coworker to come forward and say, I punched out under replenishment all the time, went out in the parking lot, smoked a cigarette, buffed my nails, called my girlfriend. All he needs is to produce one white individual who did that and was not disciplined. Maybe he's got it. It's worth asking him.
The employee I spoke to said that everyone does that.
He needs to get one of the everybody's to step forward.
Actually, did the employee that you spoke to say I did it? Yeah.
I mean, I think I'd have to phone again and just double check that. No, you're making me feel like we're asking for the person to like go on, because I was very much speaking about the complainant.
Yeah.
The questions I asked.
Sure.
And this person is also no longer employed there, and I didn't ask anything about that.
Well, it's kind of ideal. He's no longer employed there, right? The individual, the white colleague.
Right.
Doesn't
Sorry,
work
that
there
was a strange noise.
Ask him if he did it and if they knew, and if they looked the other way.
What was that beep? Does any?
I keep
No.
hearing all kinds of weird
That was
things.
really sharp.
Yeah. I'm like,
All right, I'm just making sure it's not my
I do.
imagination.
All of us.
Yeah. Okay. I'm mostly saying this to remind myself, right? So we are not making any kind of final determination of fact or anything. That happens only after a hearing. We are just deciding, is there reasonable cause to believe, so that is there even enough to go ahead and have a hearing, right? And so I think it's fair to say it's a lower threshold. We're not finding discrimination. We're just finding that there's enough. There's reasonable cause to believe that there was. If, what's on the table is either to accept the recommendation or to ask Nanette to go back and ask for more information, which it sounds like we're heading towards. And if we're going to do that, and I think Nanette, you're open to doing it, although it kind of depends on how much
Yeah,
it
if I
involves.
get like a wad
right.
of stuff
Yeah.
back, I might need help sorting it all. Thank you.
But I think we want to define carefully what more we're asking for, if we're going to do that.
So can I run over my understanding of what I'm asking for, and you'll tell me if I'm right?
Okay.
So I'm asking for an EEO1. I'm asking for a racial makeup of that concise work unit under those supervisors that are in question. And I'm asking for a record of white employees who have written up for similar violations in the same time period. And I'm asking to see the last chance agreement.
I was going to say, since we're asking them for some other things, go ahead and ask for that too. Yeah.
Nanette, if it's if you did mention that you would need some help, I am available for that tabulation and sorting through things, document review. Yeah,
Thank you, Esther.
certainly.
Would that affect her ability to vote on it though, John?
I was just thinking that.
Yeah,
Because
That's up our quorum. Ouch.
well,
Sorry.
if it ends up going to hearing, you don't want to be involved in the investigation process, because then we could lose two of you
Right.
to the hearing, since you were involved in investigation. So, and that what I would say is, why don't we see what responses you get first?
And then call
how
you.
overwhelming it is.
We can
And
help
then
you from the
let
law
us know,
department.
because we can support, that's our
Okay.
job, but we'll see what you get first.
Okay,
Okay.
sounds good.
Okay.
And I think that if you are you talking to the lawyer for the company?
Yes,
You can describe to him what you're after.
okay.
And, they might be able to sort of, the easiest way to satisfy that request. I'm not
May I
saying to
ask-
just take whatever they give you, but
May I ask another question?
Yeah.
Since I was, would you think it's advisable if they come back to me, in the next, before we meet again, with because I had asked to meet with some people thinking to get to some of these answers. I go ahead and do that still. You'd like me to proceed with that as well, if that comes up as an option?
you're talking about meeting with additional interviews with other employees?
Yes, I had asked initially for a visit with and an interview with these two employees and an employee, the employee who had worn the other employee, the white employee who had worn violated uniform, to ask if that was in fact on his shift, the photo that I have, and then to interview the supervisors. And I was given the name of another employee of color who apparently, in the complainant's view, had had experiences of I don't know, it was vague, had information to share, but I've never received a call back. So I asked the company if they could arrange for me to meet with that person. thinking that that would be a way of seeing if they were willing to share any information.
I think you're going to get more out of those employees before you ask for the further information from the company.
See, yeah, that's why I didn't, yeah.
Yeah, so I think I would go ahead and do them first.
Okay.
Would it be helpful also to, Nanette, to be able to reassure the employees? Because I'm thinking we have, there's always built in the idea that they can't be retaliated against if they are witnesses or provide information on a complainant's behalf. But just probably some reassurance in case someone is reluctant, letting them know that they are protected by the law against retaliation if they support another person's claim of discrimination.
Certainly, that's a good thing.
That might kind of smooth the way for them to feel that there may be less consequence if they talk to you openly.
Yes, yes. Thank you. I will certainly do that.
All right. Are there any other, I don't know, have we taken an action that requires a vote of any kind? We have, I'm looking at our, how these rules work.
If I heard it correctly, the investigation at this point is still ongoing. Am I understanding that correctly?
Yes.
I think we want to look at rule, what is it, 16G?
Yeah, it says, yeah, upon
I
receiving a
believe you will
report.
need a vote,
Yeah,
because you have received such a report, then the commission shall either make a finding as to reasonable cause or direct the investigator to continue their investigation upon a vote by the full members. So I think since you've heard the report, at this point, you need to vote on what you would like her to do next.
and John, that reference to full members is from when we used to have alternates, right?
Correct.
So that's just a vote of the members now, since we.
Right, so,
we've changed
yeah,
that.
if we get around to acting on the next agenda item, I could probably clean that up as well in the new draft of the rules.
Okay. So then we need a motion to direct the investigator to continue the investigation as per our conversation. So do I have
I
that?
move that we continue, that we ask Commissioner Pitt to continue the investigation.
Esther Thomas seconds the motion.
Any further discussion? All in favor say aye.
Aye.
Aye. Any opposed? The motion carries. Fabulous. We've made progress on a complaint that we've been looking at. I think that we are done with that. We've just resolved we've taken action on that complaint. We have another complaint, just to sort of hear a report, if there is one, for 20 ACRC 003, and that was with Commissioner Mobley.
Do not have a report at this time, and the investigation is ongoing.
No report at this time. And then we have the amendment to the rules that we've discussed before. John, can you remind us what we're about here?
Sure. So the last time we had discussed how actually getting a copy of the agreement between the parties would make that agreement a public record. So you wanted to get away from the idea of getting the agreement, but you wanted to leave open the opportunity to inquire of the parties about why they were satisfied with their settlement. And you wanted to use, whatever you learned from them in evaluating whether the complaint should be dismissed. So I could read the current version of Rule 24, if you would like.
Okay, and then do we have draft language?
We do. Yeah, I sent
Okay.
draft language last week.
All right, let me just make sure I'm.
So you probably have that. You might do a share screen instead, and then I won't have to read it.
Let's see if I can find it, or if somebody else has it in front of them, if they could share it. Let's just see. Proposed amendment.
Oh. That would require.
I have that, Brand, if you need.
Could you
Would you
go
like
ahead
me
and
to
do
read
that?
it? Sure.
That'd be great. Yeah.
Okay, under rule number 24, settlement agreements between the complainants and respondent. In all instances in which the complainant and respondent have entered into an agreement that each is satisfied has resolved the complaint and have so advised the commission may inquire of the reason for their satisfaction. And that's in red. And the review of the same, that part is taken out. The reason for their satisfaction skips over to in evaluating whether such agreement should result in the complaint being dismissed. So the only thing that was taken out was after it says the reason for their satisfaction, and then it skips over to in evaluating whether such agreement should result in the complaint being dismissed.
I think that just to make sure we are confident that we're talking about the same thing, I did find it, and I'm going to share it.
Okay.
I think. Are you seeing this?
Yep.
Mm-hmm.
Rule 24 language? So what was there before is the previously proposed language, and then we were concerned about the terms and conditions and reviewing the actual agreement. So we took that part out and we replaced it with may inquire of the reason for their satisfaction and evaluating whether such agreement should result in the complaint being dismissed.
Yeah, so what I wanted to show with the red line is what I changed from last month's meeting.
Right.
I would just point out that this whole rule, Rule 24 entirely is brand new.
So discussion on the proposed amendment to the rules.
If I recall, the intent of the change was to make sure that that the complainant wasn't forced, coerced, unduly influenced to accept a settlement, and that the commission could keep its option open to continue the investigation if we did not think for whatever reason it was equitable or fair, or if it was an issue that we felt that we should continue to pursue just on its merits. If is that what you remember, Nanette Brandt?
Yeah, just to be clear, I mean, I think that we understand this. It's if the parties are happy, generally speaking, right, we're generally going to be happy. So this is just on the possibility for that circumstance when, you might wonder whether they're really, whether it's all really voluntary.
Mm-hmm.
And you could imagine being presented with a party saying that they're ready to dismiss the complaint, and us wondering whether we shouldn't be looking into it further. Right.
Mm-hmm.
I mean, ultimately what it's about is whether the purposes of the anti-discrimination statute are being served. Right. And so then the question is just whether this language accomplishes that. Reason for satisfaction.
I don't know if this is, are we open for discussion, Brent?
Yes.
I don't know to what extent this is perhaps a broader topic, but I think what concerns me underneath all of this is what you just mentioned about the statute being served. Is to what extent is our purpose to, you know, in some instances, obviously, in every instance, our purpose is to remediate the wrong done to individuals to some extent, to set things right. But it may also be that a settlement agreement doesn't necessarily set a company on or a respondent or an institution or whatever it is, an individual, another individual on a right path. And I suppose I would want to know, you know, in an ideal world, I would want to believe that every settlement agreement would include some language around we'll educate ourselves differently, we'll put in place different practices. And to some extent, that's what I would like to see versus we paid this person off X amount of money. And so my intention, and my intention here is to try to be able to evaluate more fairly in cases where there is still a chance that discrimination may occur in the future, for us as a commission to have a chance to say, hold on, this respondent needs to do some more in terms of education or awareness building, as opposed to just the settlement agreement, in order to make this whole situation go away. That it's not just about that situation, but it's about creating a safe environment for the future employees, for the other employees or customers or whomever else it may be in other circumstances.
Thank
I
you.
like this language.
Yeah.
But,
So you think this does that? They bring us a settlement and we say, can you tell us why this satisfies your complaint, without asking necessarily for the agreement itself. I'm just thinking
If
myself.
I can just add, I mean, I think from a legal perspective, it just looks like it's saying, what it's saying here is that you're evaluating, they come to you, they present that they feel that they have resolved the matter and want to dismiss the matter, okay? And you as a commission, under other provisions of your rules, of the ordinance, may determine that, hey, we still want to look into this further, okay? You still have that ability. This is just saying that in determining whether, in your evaluation of whether or not the matter should be dismissed, you may inquire about, you know, why they made that, why they felt they wanted to dismiss it, which is what I understood last time was the question you know, nobody was being forced, or that we want to hear from them to hear why they felt it was satisfactorily resolved in their mind. Again, even I think you can do that anyway, but since we have it in here, this is just saying that this is asking for, that you may ask that in your overall evaluation.
Mm-hmm.
There may be another basis why you would consider to not dismiss it.
Nice, Emery.
Thanks. That's helpful to me, actually. I mean, I think you're right that we would have the right to do that anyway.
It's helpful to me too,
yeah.
because then if we're asking why they're satisfied, they might actually volunteer. Well, the company has agreed to do some training, or they've agreed to do some education, and that makes me happy. You know, that makes me feel like this won't happen to someone else in the future. That would satisfy me too. And it answers my question, I suppose. Or if they don't offer anything like that, we may be left with a lingering question. Well, you know, do we want to close the case or dismiss the case?
Mm-hmm.
But on the other hand, I guess I'm hearing, and not surprised from Nanette, I guess I'm kind of hearing tones of atonement and and all that. And I don't know in a corporate instance that they would, I don't know, just kind of roll over and just say, you know, mea culpa, we're so sorry, and we'll never do this again. And we see the error of our ways. And I'm just jesting now, but I'm just saying, I don't know how much more, since we already have that gate open, that we as a commission could see the potential for other issues if they didn't do some remedial training or something like that. But I guess the first line of acceptance would be if the complainant is satisfied and we can discern that there's been no force or arm twisting in terms of accepting the settlement, that maybe there's not a need to I don't know, keep asking that the company come back with more and more than what the person accepted initially. We do have the right, if we saw that this was a gateway to more things, and we would have to address those things later. We have that inherently built in. So I don't know if at this level we would want to see that as part of our acceptance of their settlement. Just my thoughts.
I'm open to suggestions for what action we should take at this point.
Esther Thomas speaking. I'm fine with the language. I think it's good and succinct and to the point, and it sort of, you know, draws out it states the inherent qualities of review that might be important to the commission, that are important to the commission. I'm kind of still back at Nanette's point of, and just so I've been mulling that around and wondering if that, you know, philosophically, as we look at this, which is, you know, addressing the issue by the complainant, and how far one might want to do that. And I'm just sort of struggling. I'm struggling with that a little bit because, you know, I think there's a sense of balance, and I'm not sure. No, I think there's a sense of balance that we have to reach with that, versus trying to restructure companies and making sure that, you know, they're doing their training, because if they're not complying, they will be seeing us again and repeatedly. And so I'm just sort of, I would love to hear someone else's thoughts about that, about the point Nanette made.
I've been thinking about that too. Thank you. And, you know, I think that the last time through, the reason this came up, right, we had a case that was in conciliation for a long time, and then they settled. And we didn't really have a process in mind other than just accepting the settlement and dismissing the complaint. And I'm not sure that we needed this rule, but we needed to know what we were doing, right? Because I could well imagine that, you know, suppose in the case that Nanette reported on today, right? She goes back, asks for this information, and we get we uncover a ton of, right, other complaints, corroborating evidence, the records for all the disciplinary actions that are very uneven. And then the complainant comes in and says, you know, we settled, right? I think that's, you know, the statute gives us the opportunity to bring complaints on our own behalf, right? And that could be a situation where we say, well, you might be happy, you know, you individual, but you know, but we're not. This looks like employment practices that need to be addressed. So, you know, we would sort of continue. I think that that's what this reminds us we have the right to do. Is basically.
And that's the awareness that was leading to my question, Brent. Thank you.
Yeah.
Yeah.
It also does alert, because the rules can be made open for the parties to see, that this is something that may occur.
Mm.
right.
And so they need to be mindful of, you know, when they do these settlements, that this may be something they'll inquire you of.
Right.
I think that's a very good point. And I would only add that I've seen this happen before, that a complainant in an administrative process like this decides to take the money, and they don't really care about corporate training, or actually the better example is reinstatement. I've always said that reinstatement becomes a little bit like getting two really angry divorced people, telling them they have to get married again to each other. It's conceivable that there could be a really big divide between what a complainant would like from this process and what the commission wants. And it's hard to prosecute an assault that occurred in a bar when the victim suddenly says, "It never happened," or "I'm not available for this." So these are realities, that we have to consider as well. I think that this represents at the very least, that we should be able to do to make sure that a threat or a non-binding or empty promise, hasn't been used to leverage the settlement. I think that this is probably best we can do. Even federal courts have a hard time getting fairness hearings on, large settlements. So I think this is good.
Do we have a motion to, if there's any other discussion, do we have a motion to adopt the proposed language as an amendment to our rules?
So
So
moved.
moved.
Is there a second?
Grant, if I could just interrupt for a minute.
Yeah.
It may be a good time to consider amending the motion to address Rule 16G that we just talked about. The word "full" should not be there because, as you pointed out, that was a remnant of the previous commission, which had alternates. So perhaps the word "full" could be part of the motion. We could get that stricken from Rule 16G, and then I could just make both corrections if the motion carries.
So can we consider that a friendly amendment to the motion? And if the person who made the motion would agree to that, and if the person who seconded will agree to it, then we can go ahead and vote on it.
I agree, and I move to make the motion that we accept the draft language and strike the word "full" from Rule 16G.
No, I'll second
Okay.
that.
And we have it seconded. Any other discussion? All in favor say aye.
Aye.
Aye. Any opposed? The rule is changed. The motion carries. Let me go back to mine. All right, we are to new business. And we have a new complaint, but it's related to an old complaint. Is that right? Is that what this one is?
That is correct. This is related to 0003, and the complaint that came in right before last month's meeting was subsequently renumbered as 0004. And it is related to, to the one that Latanda has been assigned to.
Okay, so so generally speaking, we make a decision about complaints coming in. Would you recommend that we consider this as sort of bundled with 03?
Well, when it was briefly discussed last meeting, without going into the specifics of the complaint, it was decided that it would be given another number.
Okay,
I think the commission anticipated that it would be investigated along with the related complaint. So I believe the commission was, without taking action on it, was leaning towards assigning it to Commissioner Mobley and having her investigate both matters.
I'm just reviewing it again to see what
It
this
is
was.
the same complainant, same respondent. It seems to be related as to the incident.
It seems as if, it is almost as if the complainant created an additional case, but their intent was to add on to the initial complaint. With that in mind, as I am investigating the complaint, I don't mind it being two separate case numbers, but I don't know what the precedence is in that regard, with there being the same complainant and the same, all of the same people mentioned.
I think my recommendation would be for us to treat it as a single case, unless when you discuss it with the complainant, you learn that there's a reason why it should be why it should be thought of as a separate incident. Does that make sense to other commissioners, or John or Yamini, if you think that's?
Well, I think for purposes of, just for purposes of procedure, I think if you're going to assign it to Latanda, I think it should be done formally with a
Oh, yeah.
vote. And then what I would need to do after the meeting is I would send a copy of this new complaint to both the complainant and the respondent to follow up what I already sent them a couple months ago, and just say the same investigator will be conducting the investigation and will conduct the investigation. It sounds like both together as part of the
Right.
same investigation.
Yeah, I think that makes sense. I didn't mean to suggest that we wouldn't take a vote on this one independently. Does that all sound okay with everybody? All right, so let's the determination that we usually make at this point is really just that we can send it to be investigated. That there's no reason why, like, it's outside of our jurisdiction, or it's an employer that isn't covered, or whatever it is. And I think as we said with the prior complaint, none of those appear to be true here. So our ordinary course of business is we assign this to an investigator, and I'm going to propose that we assign this to Commissioner Mobley, so that she can investigate this along with the previously assigned complaint. And I'll put that forth as my own motion. Is there a second?
Second.
I saw Commissioner Thomas. Any further discussion? All in favor say aye.
Aye.
Aye. Any opposed? So that complaint will be assigned to Commissioner Mobley. Okay. We have these last two new business items, our standing items, that we have been working on various efforts, sort of community efforts and publicity efforts. I don't know if there are any updates on any of those, or any new business in that line that anyone has to discuss. Oh, and we were going to bring something back. What was it? About comments.
I had mentioned the comment section of our YouTube channel potentially being closed to commentary, with and I believe John mentioned offering or someone mentioned offering an email address where if the public would like to leave comments after our meeting has adjourned, they can do so there.
So any other thoughts on this? There was a comment on our YouTube channel, not necessarily the most helpful comment, and I guess we learned that the city council has turned off their comments, and we could do the same. I think that's right. So I don't know that we need a vote. I think with your approval, I'll ask right here that the comments be turned off. Because that, all right, I see no objection, and so we will go ahead and do that. There's also a chat option. There's a chat option on the YouTube channel or on this?
YouTube provides for a live chat option. So we could turn off one or both.
So while this is streaming, there's live chat available. What are your thoughts about that?
I would not be in favor of a live chat option.
I have a question. Public comment is submitted prior to the meeting?
Correct.
Okay, then I am with Nanette. I would not be in favor of a live chat option either.
So let me just think this through a little bit. So somebody's watching the meeting, doesn't like something that we're doing, wants to let us know. That doesn't seem fair, right, or whatever. And they can't put in a comment or a chat because they're watching it on YouTube. But how did they could send us an email? Is that how this works? To be read as a public comment at our next meeting? And is it easy for them to know how to do that?
It's on the agenda for every
On the
meeting.
agenda.
And I can tell you what that address is right now so that whoever's watching can know the email address. But public comments may be submitted by email to acrcomments@akronohio.gov. And then as part of your agenda of every meeting, we check that email address to see if any public comments have been submitted. And if they are submitted, they would be read during the meeting.
So is there a way to put that sentence, at the bottom of the YouTube for the meeting?
Yes, if you guys write up what you would like as a brief description, I can, and provide that to me, I can put that in as the description for the meeting.
Okay. So, and I think John, I think you could just take the sentence right out of the meeting notice.
Sure. I'll send that to you later, Nina.
Okay. So that sounds good. Anything else for the good of the order?
Hi, this is Ellen. Sorry, I don't have
Ellen.
my video on. Hi, I'm sorry I was late. I just wanted to mention again that the Social Justice and Racial Equity, or I got that backwards, task force has been appointed, and they're looking to have their first meeting later this month, and happy to help coordinate between the two organizations however is best. I know Tamika Rose is happy to come to your next meeting to provide information. I know Bishop Joey Johnson, who's the chair of the commission, would be happy to attend as well if his schedule permitted. Alternatively, or also, additionally, someone from this group could always go to a future task force meeting to explain what the Civil Rights Commission does, just to make sure that both entities are familiar with each other and how they can best coordinate. So if you'd like to set that up for next month's meeting, just let me know and I'd be happy to coordinate.
Thank you. Your thoughts on that? Anybody have a sense of whether they'd like to make that kind of engagement happen? Or other questions?
Brent, commissioners, I think it would be great to have that kind of engagement. I mean, making sure that the ACRC is aware of other initiatives, as well as they are aware of us and the process of their functions. They might become aware, aware of something. I think it's good. I would welcome for someone to come to our meeting, and I would also love to attend one of their meetings because I'm curious and I want to support that initiative.
Ellen, are their meetings going to be open?
Sorry, it took me a moment to find unmute. So I believe they're working through those logistics now, but the idea is that similarly to this meeting, their meetings will be live streamed, and that will be the way that public access is provided, at least during the time when they're on Zoom and not meeting personally. The full task force meetings. There will also be subcommittee work, and I think it's being determined right now whether or not, to what extent those meetings will be broadcast. But yes, the task force meetings will be live streamed.
So could we all go?
Well, you could all attend, but to be able to participate, you would have to be in the Zoom meeting. So we'd have to arrange that with the chair to make sure that, we get you guys on the agenda, because, the general public isn't going to be able to just participate. We'd have to get you guys in as a guest.
I think that would be a really great idea. It seems to me that our mission is so aligned with the mission of this new task force. We're a resource for them, and I would imagine they're a resource for us as well. I think it's great.
Yeah, and I think, oh, go ahead, sorry.
I was just going to say, so just a moment on the agenda, just to share with them that we're available and for any part that we might play in their deliberations.
Great. I will just send an email. Brant, I'll copy you and John as well, just to make those connections and get those reciprocal items on each board's agenda, and we'll move forward from there.
Yeah, I don't know that. Oh, go ahead, Nanette.
No, I simply wanted to say that I like the idea that Nancy proposed of us all being included in the actual meeting, just so we're visible, because I think there's something to us maybe having different publics. And when we visit with one another, if we were visible to those publics, it might be a way of people saying, oh yeah, that's the commission who I could send my complaint to. And so we don't necessarily all have to have voice.
So that's going to be a question for how they want to handle, requests for guests to their meeting. I was going to say that I'm not sure that we need to. Well, you tell me. My feeling right now is I'm not sure that we need to. They're going to be pretty busy. I think that they're in a fairly short time frame. I'm not sure that we need to ask them to come talk to us unless there's a specific, working agenda item that we can address. That's kind of my thought about it right now. I should mention I'm on one of the subcommittees. I think, although I keep losing the email and trying to find it again for some reason, my Outlook search function is not working very well. But
that sounds right, Brant. I know I've seen your name on a list. So
yeah, I'm pretty sure I'm on the housing subcommittee. And I think that Marie also thinks that she's on a committee. So there will be we will hear about it in other ways, I think.
Sure. I'll reach out to Tamika and I'll let her use her expert judgment there on the best way to connect the two groups, but we will definitely do that before the next meeting.
Okay. Thank you.
Sure.
Are we all, anything else?
I thought
It's
there was,
kind of-
I thought there was an item that Nanette wanted to mention regarding a forum at her church.
Oh, yes.
Thank you, John. So
Yeah.
I have been feeling the need to organize an event, and so we're in the planning stages, early planning stages, to host a conversation or a forum for public forum within a webinar with invited guest speakers. So on the Black Lives Matter movement, as it is not only locally but nationally, but really to shed awareness on the kinds of discrimination that have historically occurred and also are perpetuated in lived experience now. And I think I've been seeing a lot that's happening, and Akron does a lot of conversations, and there are a lot of forums, and there's been a lot of conversation, but some of it I think leaves, I think there's a certain segment of our population who doesn't understand some of the basics about how this all happens locally and what this all means locally. And so my intention is to try and bridge that gap. And I'm basing that off of some of the conversations I've had and some of the explanations I found myself trying to give. And so I wanted to create a forum for other voices to be lifted up and to be offering, specifically voices of people of color, to be lifting up those concerns and explaining things locally. And so I understand that Black Lives Matter is a particular movement and has a particular focus. But I was thinking and wondering whether the commission would want in any way to be a part of that conversation, or would want to even co-host it because of a discussion around the kinds of discrimination that occur. And there might be a place to speak into that if any of you were individually interested or as a commission. And I bring this up because we've always been speaking about what sort of educational or public offerings we should be a part of or be sponsoring.
And so what would sponsoring this entail? You happen to know we have no money, so.
No money. No, I mean, I'm very grassrootish, right? We have all the webinar functions set up at the church. It really would be in name only, and it would mean showing up and being some part of a panel or speaking or raising questions or sharing information to some extent. Our previous commission member, Francia Lash, is helping me with this, and he's now working in the mayor's office and will likely will likely moderate the conversation. And we're, so it's really early stages. We're hoping to do it before Thanksgiving though, and would just share it widely in various community circles that it would be happening.
All right, what's your pleasure?
I'd love to participate. I think that sounds wonderful.
I would as well.
I am to participate.
I'm in.
You have a lot of takers.
Wonderful. Thank you so much.
And I think that I'm counting those also as votes to say that we'll co-host for whatever that means. Yeah. I had mentioned before the meeting, I'm not sure if everyone was here, that how, technically a lot of the subject matter would not actually be in our jurisdiction to cover, right? But that, we have an educational mission as well. And that certainly is part of the civil rights scene in Akron today. So I consider that, under our jurisdiction in that way. All right, thank you. There's one other item I meant to bring up earlier that I should have brought you up to date. There were a couple of people who got some of this email, but I don't think everybody did. You might remember that we had an outstanding question because the complaint that was assigned to Commissioner Mobley, right, they had checked off that they'd also filed an OCRC complaint, and we had been holding off to see whether we should coordinate with OCRC on investigating, complaints that are filed with both entities. So just to complete the circle and make sure everyone's in the loop, we did get an email back from Bradley Dunn. That they are not allowed by statute to share information with us. So there's no way for us to sort of combine efforts in that way. Even though there are other arrangements made between the feds and the state, but since we don't have that in statute in place for us, there's no way to do that. So we got that answer, and so that means that the investigation is just going to proceed on our own, even though the people that you interview might have already been interviewed by someone from OCRC, right? They're just going to be independent investigations. Just to let you all know that happened, because I'm sure that circumstance will arise again. All right, if there's nothing else, I'll entertain a motion to adjourn.
Mr. Chairman?
Yeah.
Sorry, one last thing. Item number 5. I should probably just report that no comments were received this month for the public comments. Thank you.
Thank you. The invitation stands.
I move to adjourn.
We have a motion and a second. All in favor say aye.
Aye.
This meeting is adjourned. Thank you, everyone.